and welcome to our monthly webinar jointly presented for the Assange Defense and Stella Assange, Start with the Truth. I'm Ileana from Stella's campaign. For this month's webinar, we have a panel of experts to help us prepare for the May 20th new hearing date, which is in 3 days on Monday. A reminder for those of you who can make it to the Royal Courts of Justice in London, please be there from 8:30 a.m. And for those of you who can't make it to London, we will be doing a live stream with the Free Assange campaign. So please help us spread the word and tune in. You can also send your pics and video in solidarity to our dedicated Telegram channel, Assange Supporters Action Content, if you'd like to be part of the live stream. All details in the description below. Thank you guys for tuning in. And now I'm going to introduce our amazing expert panelists. Our first speaker will be Chris Hedges. Chris Hedges is a Pulitzer Prize winning author and journalist who was a foreign correspondent for 15 years for the New York Times. And then that will be followed by Carey Shenkman, who is a human rights attorney specializing in freedom of expression and technology. He is a co-author of A Century of Repression, the Espionage Act, and Freedom of the Press. And lastly, we will end with Jesselyn Radack. Jesselyn heads the Whistleblower and Source Protection Program at ExposeFacts. Her work focuses on issues of secrecy, surveillance, torture, and drones, where she has been at the forefront of challenging the government's war on journalists and their sources. Welcome, and thank you so much for joining us today. Chris, if you're ready, do you want to go ahead?
This is a fundamental assault on freedom of the press. That is the way to summarize the persecution of Julian Assange. It began in 2010 after the publication of the Iraqi war logs. These were files allegedly provided by Chelsea Manning to WikiLeaks. That's an important thing to remember. Unlike Daniel Ellsberg, Julian did not actually leak the files. He functioned in the traditional role of a publisher, a whistleblower, somebody who saw malfeasance and crimes being committed in the darkness of the government apparatus, decided that those crimes should be provided or made known to the public. The content was massive and highly embarrassing to the U.S. government because it exposed not only war crimes, but the lies that had been spewed out to sustain the wars in Iraq and Afghanistan. The torture, the high number of civilian deaths, which they were covering up, etc. And so the assault began almost immediately. Michael Ratner and Len Weinglass. So they asked for a meeting with Julian, and they said that they feared that the U.S. government would come after Julian with the use of the Espionage Act, and Julian's answer was, "Come after me for what?" And that started this long, tragic, horrific kind of judicial farce that has been going on ever since. It was clear that Julian would be extradited. I won't get into the whole Swedish complications, but the manipulation of Swedish law, charges against Julian that were false, etc. He took refuge for 7 years in the Ecuadorian embassy. The government changed, so he no longer had a government that was willing to grant him or continue to grant him asylum. They allowed the British Metropolitan Police to break in. He was hauled before a court. Now, the only crime they could charge him with was skipping bail, because by going into the embassy, he'd skipped bail. But nevertheless, they put him in a high-security prison where he's been held now for over 5 years. And that whole those court cases, some of which I have attended in London, others of which I have followed online, have just eviscerated the most basic tenets of due process. Thrown out, they refused to classify him. UC Global, the Spanish security firm in the embassy, videotaped or made audio tapes of all of his meetings with his attorneys, which eviscerates attorney-client privilege. That alone should see the case. As a journalist, he's not an American citizen. WikiLeaks is not a US-based publication. How can you even use the Espionage Act, a 1917 act passed by Woodrow Wilson, ostensibly to go after people who provided information to the enemy, or the rough equivalent of the British Foreign Secrets Act, but in fact it was used almost immediately against dissidents, including that and the Sedition Act, including throwing Eugene V. Debs, the socialist candidate, into prison, shutting down big publications appeal to reason, the masses, etc. And so the anomalies within the case have been so egregious that I think quite consciously the British judicial system has made it very hard to cover. They've restricted the amount of people who get into the courtroom. Oftentimes when we pulled up links, we had no audio, we couldn't hear, there was no connection. I was in the courtroom for the 2-day hearing. This was his final appeal. There was roughly 2 or 3 dozen people allowed in, and in this new upcoming hearing on the 20th, they're not allowing any links outside of the UK and maybe Wales or something. I think even if you're in Scotland, you can't get it. So there's been a real effort to cover it up because it is, anybody who looks at the details, it's a horrific judicial embarrassment. He was in the High Court. The extradition request, Judge Pulitzer denied it because of Julian's very precarious mental and physical health, as anybody who would endure the torture that he's been under, or what Niels Melzer, the former special rapporteur on torture for the UN, called slow motion execution. And so they didn't extradite him based on the draconian conditions in the American prison system, which are very real. I teach in the prison system through Rutgers University, but they accepted all the other points. So Julian was allowed to, the United States government filed an appeal. That appeal was accepted. Then Julian went before a 2-judge panel. That was the last time he was in court. He wasn't physically in the court, but went before the 2-judge panel, and they ruled whether he could appeal that final extradition request. They allowed him to do so on 2 points, minor points, I would say, legally, and that is, of course, where we are. We should also say that the court accepted a diplomatic note. It has no legal validity, which gave assurances that Julian would be well treated in the prison system. He would not be sent to a supermax prison. They wouldn't use what they call special administrative measures, or SAMs, against him. This diplomatic note has no validity. There was an escape clause that said, if he violates the rules, well, so who runs the rules? Who decides what the rules are? And then just on the legal aspect, I would also say that the demand for extradition came after the release of something known as Vault 7. Vault 7, published by WikiLeaks, exposed the CIA's hacking tools into telephones, cars, etc., even when they're turned off as kind of monitoring devices. But that's not part of the extradition request. But there's no question that if he was extradited, that would be added. He's facing 175 years in prison. He's being sent to the Eastern District Court in Virginia, which is where these quote-unquote terrorism cases, national security cases go, because they're all hanging judges. Gordon Kromberg was one who was quoted extensively in the court. And then just to close, I would say that as a journalist, this is devastating to those of us, such as myself, who have possessed classified documents. I published them in the New York Times. It would set a legal precedent whereby any journalist who possessed these documents, just possessed them, didn't even publish them, it would be criminalized, much less, of course, publishing. It's the end of investigative journalism as we know it. And that's why, even with some reticence, the major publications, the New York Times, El País, The Guardian, published a joint letter demanding that Julian not be extradited. We won't get into the animus that they had and have towards Julian or why, but that essentially in a brief summary lays out, what they've done to him and the very, very, very real danger those of us who are journalists face.
Thank you so much, Chris. I think we were going to go to Carey next. So go ahead with that.
Thank you so much, Chris. My name is Carey Shenkman. I'm a human rights attorney, as Elena introduced. And I just want to give a little disclaimer. So I'm speaking today in my personal capacity. I did previously work on the legal team in the Assange case. I was also an expert witness in the London proceedings, but my comments today are in my personal capacity as a scholar of the Espionage Act. So I want to very briefly try to cram 100 years of history into 10 minutes. My co-author and I teamed up with a media historian. For years, we traced the 100-year political history of the Espionage Act, publishing a book titled The Century of Repression, the Espionage Act and Freedom of the Press. And there's one thing I want to emphasize about this book, and I think it's kind of summed up by our cover. Our cover has faces on it, and that was a very deliberate choice, because ultimately, these cases are about people, and they ruin people's lives, even if these cases lead to no prosecution ultimately. But legal process is expensive, and these cases do have an impact. And in fact, when we're looking at the history of these people, as Chris already referenced, this law was passed and utilized during World War I to decimate anti-war opposition and labor movements. Here's a picture of Woodrow Wilson requesting Congress for a declaration of war. He threatened disloyalty with, quote, a firm hand of stern repression. Of course, it was used to imprison presidential candidate Eugene Debs in response to his famous anti-war speech. Bill Haywood, the leader of the Wobblies, there was a mass trial against the Wobblies, imprisoning them in mass in part for their anti-war resistance. Of course, the magazine, The Masses. And this led to one of the most vibrant oppositions to war in US history. Another somewhat unknown thread about the early Espionage Act is that it was really instrumental to the rise of the careers of J. Edgar Hoover and Roger Baldwin. Of course, J. Edgar Hoover went on to be the head of the FBI, and Roger Baldwin, he was at first the head of the Civil Liberties Bureau of the American Union Against Militarism, but then went on to found the ACLU. The Espionage Act was also implicated in prosecutions and investigations of the Black press, ranging from World War I to World War II. Here's a photo of John Senstack, the young editor of the Chicago Defender. And in fact, J. Edgar Hoover was nearly on a weekly basis sending copies of Black publications to the Justice Department asking for prosecution under the Act. In fact, this was because the Black press was a leading voice for civil liberties and anti-war resistance throughout that interwar period. There was also efforts to investigate the Chicago Tribune during World War II, and the act was arguably what sparked McCarthyism. The initial case and investigation that led to the Red Scare was of State Department diplomats and involved an alleged Espionage Act conspiracy and break-in to a journal, the Amerasia Journal's offices in New York City. Here's John Service, who was considered one of the most brilliant diplomats in US history with respect to US-China policy, and his career was effectively ruined by Senator McCarthy on the right. Very famous is the case of the New York Times and Daniel Ellsberg, related to the Pentagon Papers case that went to the Supreme Court. And there are also investigations of the New York Times and other lesser known publications like Beacon Press, with an interesting side thread of Senator Mike Gravel, who also led to full publication of the Pentagon Papers and was personally investigated and got calls by Richard Nixon. Here's one of our panelists with her client, Thomas Drake, who blew the whistle on abuse and waste in the NSA and was cited by Edward Snowden as one of the inspirations for his whistleblowing. And of course, we have Barry Pollack with his client, Jeff Sterling, who served time, again, under the Espionage Act, and numerous whistleblowers that are well known today. So what do these cases have in common? What they have in common is that from the beginning, the Espionage Act was about punishing, quote, interference with the foreign relations of the United States. It's lived in the shadows of virtually every military conflict and foreign policy controversy in the past century. And where does that lead us in 2024? Julian Assange is charged with 17 counts of violating this law for his role in publishing extensive human rights violations and war crimes in Iraq, Afghanistan, and around the world. Of course, when we hear this law called the Espionage Act, a lot of folks ask first, well, where's the espionage? But in fact, this law punishes way more than the common definition of espionage. It punishes whoever having unauthorized possession of any document relating to the national defense, who willfully communicates that to a person not entitled to receive it. This is a key law that's used to prosecute whistleblowers who are not accused of working for a foreign government. That language that I just showed you is not limited to spies in the common definition. It applies to government employees, the public, and even non-US citizens. In fact, it broadly punishes conduct related to national defense information. But a lot of folks will ask, well, national defense information, that sounds like pretty important stuff, right? But it does not mean military secrets, codes, or closely guarded information. It does not even need to be classified. It can include evidence of torture, war crimes, corruption, or government criminality. It's a contentious and controversial law. In fact, there are serious scholars that call this constitutionally problematic, labyrinthine, and assert that public speech in this country since World War II has been rife with criminality. Even former Attorney General Eric Holder has called for its revision and amendment. So a few key principles I want to emphasize. One, what's the impact of this law if this happened elsewhere? Let's put on our just imagine hats here and think about what would happen if this exact same fact pattern happened in Russia or in China. In fact, we saw there's a Wall Street journalist, Evan Gershkovich, who was investigated in Russia for his reporting there. And this was widely condemned in the US press, widely condemned in a way that we did not see in cases like the Assange case. And I don't even want to imagine if China, for instance, sought the extradition of a US journalist. It would be very clear the political motivation of those cases. The second question I want to ask, is Assange a whistleblower? No, he's not a whistleblower. He never signed an oath of loyalty to the US government. He's an Australian citizen. Australia is not in the US. Whistleblowers are commonly referred as folks who are inside government, who signed an oath of allegiance, who made that commitment. Assange doesn't have that obligation. He's not a US citizen. And this case would grant extraterritorial jurisdiction. Legally, he is not in the same position as someone like Edward Snowden or Chelsea Manning, because this case would effectively set a precedent that this law applies to anyone on earth. As a legal matter, Julian Assange is in the same position as anyone on earth in any country, and that's a different legal position than a government insider. The third question that this case raises is what counts as hacking? And a lot of folks will say, well, there's the Espionage Act things, but there's also the allegedly icky hacking stuff, as the indictment alleges. But in fact, the law, the Computer Fraud and Abuse Act that's predicated on, is contentious as well. It was passed in the 1980s, literally in response to a Matthew Broderick movie. Reagan saw the movie War Games, and it led to policy change during his administration. So I'll wrap up just briefly saying that it's effectively impossible for folks to get a fair trial under this law. The law is stacked against defendants. There's no opportunity to argue a public interest defense, and it's selectively enforced. Government officials do provide information to the press every day, but to no consequence. Only the critics, and of course, the folks that I presented to you earlier on, the ones who are presenting truth to power, the ones that are anti-war, are the ones prosecuted. So I'll go ahead and stop there and appreciate this panel and your contributions to this important conversation.
Thank you so much, Carey. And finally, we have Jesselyn. Go ahead, Jesselyn.
I'm glad to pick up on that. Thank you to Chris and to Carey and to you for what you just said. Basically, in terms of the assurances that people are hearing about, basically, the US recently provided diplomatic assurances to the UK High Court to prevent a final appeal by Assange against the extradition. So they promised that there would be no prejudice with respect to his nationality. And they also promised that there would be no death penalty sought or imposed. And third, they promised that he can raise First Amendment protections. And those are all problematic. I call this human rights theater, basically, starting with the death penalty, because Assange is not charged with a death-eligible offense. Also, it has taken 5 years for them to issue this assurance. And basically, that has to do with extradition law, which is not my area of expertise, but basically, under extradition treaties, countries will not extradite to other countries where the death penalty is a risk. And that's why they were taking that off the table, but it was never on the table because it's not a consequence of the 17 charges that he's facing. In terms of the very idea that he can seek to rely on a First Amendment defense, it's really a bunch of bunk. He can seek to rely on a herd of goats if he wants. He can seek to rely on anything. Anyone can raise anything as a defense. So it's very disingenuous to use that. I think that's what Stella Assange, his wife, meant by it being kind of a weasel word, that he could seek to rely on a First Amendment defense, because it's also very disingenuous because people who have tried to raise First Amendment in these cases, the US has specifically, in a number of different Espionage Act cases, done motions not only to preclude a First Amendment defense, but to preclude even the word First Amendment, even those words, and to preclude the word whistleblower, and to preclude the word journalist. So it's very slick and dangerous to kind of say that he can raise a First Amendment defense. He can raise any kind of defense he wants. That's always been his prerogative. But the thing is, in these cases, they are strict liability. Whether or not he disclosed the information, possessed the information, did he or didn't he have this information? His good intent in doing so is not allowed to come in during the case in chief. It would only be allowed to come in during sentencing after he had already been found guilty. So to the extent he wanted to talk about First Amendment, based on my experience, that would be something he could only really talk about at the sentencing phase, because the government would certainly file motions to preclude anything based on the First Amendment during the preliminary motions phases, and would do that quite vigorously, and has done that in pretty much every Espionage Act case against a whistleblower. And yes, there is a distinction because, of course, Julian is a journalist, but him being a journalist is crossing the Rubicon. It was bad enough that this law has been used against whistleblowers, but I always said the war on whistleblowers is a backdoor war on journalists. And here it's coming to full fruition with Julian Assange. And it is going to radically alter the landscape of press freedom in this country if Assange is in fact extradited.
Thank you so much, Jesselyn. Does anybody have any responses or anything to add?
I would only add that the United States is in a very precarious position, or the Biden administration is in a precarious position. Biden is running neck and neck in the upcoming presidential elections with Trump. Some polls will have Trump ahead and some polls will have Biden ahead, but it's very close because he has perpetuated the genocide in Gaza and been a full partner in the genocide in Gaza. He has really damaged whatever support he might get from the Muslim American community, as well as college-age kids, young people who quite rightly have been calling out this genocide and the U.S. complicity with this genocide, and being met with very draconian force. I've spent time at Columbia and Princeton. I live in Princeton, arresting these people for nonviolent protests. So the big question is whether he can afford politically to extradite Julian before the elections. I think most of us believe he cannot. But so much of what has happened in London is a whole kind of holding pattern. As Julian deteriorates within the prison, it serves the purposes of his torturers in the UK and the US. So I think we're all watching and expecting the UK courts to drag this out so that this doesn't become a political liability for Biden before November. Again, that's conjecture. We don't know, but that's an assumption that I give, a great deal of credibility to. I don't know if other people want to address that issue.
A collateral issue to that is just the fact that this is punishment by process. Julian has already spent more time in Belmarsh than most of the people who have been sentenced under the Espionage Act, and he has not been tried or convicted or sentenced, yet he has already been languishing in prison longer than most people's sentences. And there are a number of exit ramps the US could take, and I don't understand why they don't take an off-ramp and ditch this case and instead are dragging it out more. But by dragging it out more, as Chris noted, this becomes punishment by process. So regardless of whatever happens eventually in the criminal case, he is already been effectively detained. I mean, he's already imprisoned in a very harsh dungeon of a prison. So again, does he deserve more punishment? I mean, on top of the time he has already served, which has already been longer than all the other people who've been sentenced under this law. It really needs to come to an end. And Biden didn't have to take up this case and continue it and press on. And I can only imagine there might be pressure coming from the national intelligence and security agencies on him to continue this persecution.
This sort of leads to one of the supporter questions that does tend to come up again and again as to, Julian has been in Belmarsh for 5 years now. And I keep getting this question, how is that allowed? How is it legal to have him be in a high security prison when awaiting extradition? Is that a law? And does the UK not have any autonomy as a country? It sounds a bit rhetorical, but I think people actually do want to answer to that. If any of you would like to expand and clarify.
Echoing what Jesselyn said about trial by process, I think that's one of the key things to keep in mind. When we have complex legal proceedings, there's a temptation, particularly among lawyers, because that's what we do and we work on, to talk about the abstract, to talk about the law, to talk about what are the elements of the offense, what's going to be the outcome of this prosecution. But the outcome is in the present. And if we look historically at these cases and the objective, ultimately, historically, the objective of going after Debs, of going after Haywood, and then you look through during the McCarthy era, you look at Ellsberg, and then you look at the Obama era prosecutions, the objective is to stifle dissent. That is the objective. It's not about a case. I mean, the precedent is second to that, but it's really to stifle. And process is what stifles. It sends a message, it expends resources, it creates friction. And that is the key, no matter what happens at any stage of a case. And echoing also what Chris said, which I think is really important, is a political dimension too, is that these cases are inherently political. Obama's DOJ declined to prosecute the exact same facts as alleged in the indictment. And that's very important. A similar thing happened with Daniel Hale, the drone whistleblower, and also a client of Jesselyn, who she can speak to, where you had a shift in the change of DOJ. And that's very important because the decisions to prosecute are political decisions. We look historically at Nixon and FDR, who faced huge potential for Espionage Act prosecutions against the press during election years. And this was actually an issue for both of their campaigns. We learned decades later from the Nixon tapes, we learned from unsealed records during the FDR administration, from the grand jury of the Tribune, that incumbents don't like going to war with the press during election years. So maybe history will inform us today. But on the other hand, as Chris also points out, Biden can barely keep a handle on taking a remotely humane policy when it comes to active genocide.
Yeah, I mean, I cannot stress enough that this is, in my belief, driven by the CIA. And the CIA is a state within a state, like the military industrial complex. I don't know how much room the Biden administration has. We know that there are negotiations between Julian's lawyers about a possible plea. We know that that includes the possibility of him being sent to Australia as requested by the Australian Parliament. But I think we can't ignore how venal and vicious the CIA is. It's important to note that the CIA is very different from intelligence agencies, for instance, in the UK, where there's a separation between intelligence gathering and operations. The CIA has largely morphed into, we have 17 intelligence agencies in the United States, but it's largely morphed into an operational arm of the US, it's kind of black ops, its own drone program, its own virtually special forces type programs. I worked, of course, in war zones, including the Middle East, for 7 years. These are just death squads. They kill, assassinate, extort. That's what they do for a living. And that is their mindset. And that is why we saw a discussion of a potential assassination or kidnapping of Julian while he was seeking refuge in the Ecuadorian embassy in London because that is primarily what they do. So I think that understanding what the CIA is, how it thinks, the fact that it is bent on vengeance, and the fact that it is an extremely powerful organization that is often beyond the reach of the executive government is extremely important.
Thank you, Chris. Is there any other comments?
This kind of plays into the assurances and why they're problematic. I mean, for so many reasons, they're unenforceable because the US doesn't have a track record of good faith with respect to Julian Assange. Just as Chris just noted, the fact that the CIA had assassination designs on Assange is outrageous, totally believable, but outrageous. And that fact alone, that they were planning on how to kidnap or assassinate a journalist, should normally be grounds for the case to completely collapse right there. But also another reason, these assurances are not binding under international law. They're diplomatic, and there's no enforcement mechanism for these assurances. There's no penalty for reneging on them. And there are big fat loopholes everywhere. My favorite is that ultimately, whatever the assurances are, they are from the Department of Justice. That is from the executive branch. But the loophole in the assurances is that ultimately it's up to the judge. So there you go. It's an entirely different branch of government. It's ultimately up to the judicial branch. So again, this is, like I said, a lot of what I call human rights theater with these assurances that are being given, and it kind of puts the lie to how empty they really are.
I mean, with this, like you're saying, human rights theater, is there any sense that you get about how the UK can sort of act in this way and they can get away with it? I mean, is there any sense of why ask for the assurances that's unprecedented? Can you speak to any strategy that you're seeing here?
I mean, we know from the profiles of the judges, they're all intimately, and the prosecutors, they're tied to the intelligence community and the defense community. So the people that they appoint to prosecute and oversee the case are essentially in bed with the agencies that are the engine of persecution. And that's why they want to send Julian is extradited to the Eastern District Court of New York, because it's the same dirty kind of playbook. So that's just been from the inception. Remember when Julian was hauled out of the embassy by, of course, a violation of the sovereignty of Ecuador, that's sovereign territory, the embassy. And remember when he was hauled behind a judge, and the judge was caustic and insulting to Julian even before Julian opened his mouth. But that is a kind of indication of they've been very careful about who they've appointed to oversee this case. And there's all sorts of Declassified and other UK journalists have done a really good job of exposing that these judicial figures are essentially part of the apparatus that is determined to get Julian.
All of these cases have been brought in the Eastern District of Virginia because it is the most conservative court in the country. And it's also inside the Beltway. So your jury is going to be composed completely of people who either work at or have family members or friends who work at the NSA and the CIA and the DIA. So this is very deliberate forum shopping by the government to bring all these cases in the Eastern District of Virginia. That's a very deliberate choice, but yet that was strategic on the government's part. And they have called it the rocket docket, but one of the people who was a defendant in an Espionage Act case, John Kiriakou, called it the espionage docket, the Espionage Act judge. Again, this is right now, at least the way Assange's indictment is right now, it's in front of the same judge in the same court that recently had sent Daniel Hill to prison for revealing the overselling of the drone program and its effectiveness and the undercounting of civilian casualties in the drone program. And it has been the court that went after John Kiriakou, Jeff Sterling, and most of the other people prosecuted under the Espionage Act. They know they have a sympathetic bar that would be hearing this stuff.
Emphasize the implications of this case for journalism broadly as well, because this case is threatening to set a precedent that the DOJ and intelligence agencies in the US have literally been licking their lips for decades. This isn't years, this is decades. We see back to the Reagan administration and the rapid expansion of the CIA in the 80s. There were attempts to pursue these theories against the press. According to the indictment of Assange, he allegedly, quote, encouraged sources to circumvent legal safeguards on information, provide that protected information to a publisher for public dissemination, and continue the pattern of illegally procuring and provided protected information for distribution to the public. In an indictment, that sounds nefarious, but correct me if I'm wrong, but that sounds a little bit like maybe something that Chris has done during his career. And any serious journalist, not just in the US, but around the world, does. But what this indictment does is it attaches criminal suspicion to routine journalist activities. It cites use of anonymity tools, secure communications as means of a conspiracy. And that would criminalize literally any serious national security journalists on earth. This precedent is so unbelievably dangerous.
Okay, great. Thank you so much, everyone. For just this last bit to wrap up, could you each speak to a little bit about what you want the general public to know, our supporters to know about Monday, what they should look out for? What are your takeaways on that?
Well, it's important that people get to the streets. And, I was good friends with Michael Ratner, who was one of Julian's lawyers at the beginning. We lost Michael a couple of years ago. Michael is one of the great human rights attorneys in contemporary American society, got legal representation for the prisoners in Guantanamo, on and on and on. But Michael always said, and I met Julian, I would travel to London with Michael, as how I met Julian at Michael's, suggestion. There was a moment with Baritza was actually said in the middle of the courtroom that she was having difficulty hearing because of the chanting from the street. This is extremely important that people get to the street. We have seen with the current genocide in Gaza that it's been the courageous actions on the part of students across the country that have been the only real effective pressure point on the Biden administration. And that is true also in the case of Julian. They are cognizant, number one, of the judicial farce. I mean, they did go to law school, however cynical they are. And number two, they are also cognizant of the fact that there is widespread global revulsion at what is being done to Julian. And we have to make our voices heard. That is extremely important. So the last time I was in London for the 2-day hearing, crowds in the hundreds, it is vital that we continue this kind of pressure, these kinds of acts of even civil disobedience, because they see it and they fear it. That's my one plea. I won't be there this time. It's only, I think, a 2-hour hearing. They're not going to make a decision. But I have been pretty rigorous about getting to London or getting on the feeds to follow the case. Yeah, that would be my one plea, that people get out in the street and make their voices heard.
Just before we go on, I would just like to say that our campaign, our side, there are people who think that there will likely be a decision this time. I think we know from following this case, as you guys definitely know, we never really can predict. So that's what I'm hearing, that they think likely will be a decision because it's straightforward. But like we've pretty much discussed in this, it's pretty straightforward what they should be doing anyway. So we'll see. But we're really sort of operating on the idea that the decision may likely come out and we don't know what it will be. So yeah, so please, everybody, please come to the Royal Courts of Justice. We need, as Chris says, as much noise as possible there. So if you are in London or you can make it to London, please join us there. Carey, would you like to do some closing remarks?
Yeah, actually, I had worked for Michael Ratner for many years, and I wanted to share an experience that we had in Berlin. Actually, he talked about it in an interview some years back, but it actually involved representatives of the landless peasants movement in Brazil, the MST. And it was a conversation that we had with them. For folks that don't know the MST, their movement, 1.5 million people, they're fighters to get land back for displaced and impoverished farmers who have no land. And they changed the conversation to Julian Assange, WikiLeaks, and Chelsea Manning. And we're very interested, and we're talking about those cases. And at the end, we asked, why do you care about this? Why do you have interest in this? You're landless peasants in this movement in Brazil. You're fighting to get land back. What's your interest in these topics? And they said so forcefully, all the work, all the material from whistleblowers, what was published by Julian Assange and spearheaded, it's a blow against imperialism.
Thank you, Carey. That's so true.
I mean, this whole thing is very surreal and at the same time all too real. And I totally echoing what Carey said and what Chris said about getting people on the ground involved and to pay attention. Part of what we're working against is that these proceedings are shrouded in secrecy. And that is by design. The Espionage Act, the very way it works is a number of the procedures take place in a classified setting, whether it involves classified information or not. Even as an attorney in an Espionage Act case, in Daniel Hale's case, there were hearings that were completely unclassified that I was shut out of and not allowed to attend. So yes, make noise, because especially this law is deliberately designed to prevent noise and to prevent dissent, as Carey also pointed out. So yes, we need to make noise and pay attention. And the fact that, at least in the US, they have tried so hard to vilify Assange is part of the whole strategy. It's under wraps and making the secret law transpire in a secret proceeding against somebody who doesn't have a voice right now. So for all the times that Julian has been the voice for other people, the time is now for us to be his voice.
Thank you. That's a great note to end on. Thank you, panelists, for coming on. We really appreciate the time that you're taking and the care. And also thank you everyone for watching. Please remember to tune into our live stream here on Free Assange News and on Assange Defense on Monday. We will start the stream at 6:30 a.m. BST, and then we will go live from outside the Royal Courts of Justice at 8:30 a.m. For those of you that can actually make it down to the courts, I'll see you there. Thank you. Free Assange.
Thank you.
Free us all. Thank you, everyone.